Executive Vice President of the Special District Association. So we provide general counsel legal services, also special counsel for particular projects, and we also provide a lot of assistance on elections. So that's a little bit about me and my firm. I run into employment law issues a lot, as you can imagine. And so that's what I want to talk to you about today. And just to kind of set the tone for this, employment law is a heavily regulated area. There are a lot of federal laws and state laws, sometimes even local laws that come into play. And there are no bad questions here. There are no dumb questions. So please put any questions you have in the chat. And I hope that everybody feels comfortable just asking whatever it is that you need clarification on or something that you find confusing. But it's a complex area, so do know that going in. I'll do my best to demystify it for you today. All right, so here's a little roadmap about some of the topics that I'll be covering. I'm going to start with talking about at-will employment and what that means and how anti-discrimination laws fit into that. And then I'll talk a little bit about wage and hour, and then I'll do a deeper dive into Colorado's new paid sick leave law. This applies to all employers. So even if you just have one employee, this one applies to you. So I want to make sure that you've got an understanding of how that law works. Then I'll talk for a minute about family and medical leave and also Colorado's new equal pay statute. And then I'll run through a variety of other laws just so you're aware of them. Many of them won't apply to you, but I find it's good to know even the things that don't apply to you and the things that you don't need to worry about. So, and I am gearing my presentation today towards very small employers. So if we come across a law that only applies to employers with 20 employees or 50 employees, I'll mention it and then tell you you don't need to worry about it. Okay, so at-will employment, what does that mean? So Colorado is an at-will employment state, and that means that the relationship between the employer and the employee is completely voluntary. So either side, the employer or the employee, can terminate the relationship at any time for any reason, with notice or without notice. An employee is always free to quit, and an employer is always free to terminate an employee. So easy enough, right? No. So it sounds very straightforward, but the problem is we now have a lot of exceptions to the at-will employment doctrine. The big one is anti-discrimination laws. So these laws say, well, you can't fire an employee for any reason. You can't fire them because of a disability, because of their race, because of their religion, because they're pregnant. For public policy reasons, these are not legitimate reasons to fire somebody. They're not based on their job performance. So this is a huge exception to the at-will employment idea. And, I think in this day and age, most employers know this. They're not going to write as the reason for termination because of the employee's religion. I mean, that's just not going to happen. The situation that's more common is where you have an employee who's a member of a protected class, which means they have one of these attributes that you see here. I mean, a disability or their sex or their age, they're over 40, something like that. They have some characteristic that puts them in one of these protected classes. And say they are not the best employee. You've got some job performance issues, maybe some attendance problems. They show up late for work and for no reason, and they don't call in. And finally, the supervisor is just fed up. They say, I've had it with this person and I want to terminate them. And that is where you really need to have documentation of the job performance issues. So I'll just make up an example. So you have a pregnant employee and she, it's not your best employee. She's tardy a lot. And she comes to you and says, I'm pregnant. And you think, oh, great. You know, we've already having these attendance issues and now you're pregnant and there's going to be doctor's appointments. And then of course, some kind of leave when the baby arrives. And so you think I've had it. This person is not doing a very good job. They're tardy a lot. I'm just going to terminate her now. At that point, you need to check, do you have documentation of those job performance issues? If you do, then you will be able to defend against a discrimination claim. If you don't, it will be very difficult to defend against a discrimination claim. So say you terminate the pregnant employee, she turns around and files a discrimination claim under the Colorado Anti-Discrimination Act, CADA. And you say, no, I didn't fire her because she was pregnant. I fired her because of these job performance issues, because she's tardy all the time. That's why I fired her. If you have documentation to substantiate that, then you're in a pretty good position. If you don't, it's very hard to defend against that type of claim, and you really open up the district to liability. So I often have this conversation with clients where they say, I want to fire this person. We're an at-will employment state. I can do whatever I want. And I say, whoa, let's slow down. Why do you want to terminate them? And what documentation do you have to show that you talked to this employee about their performance issues or their attendance issues, you know, whatever the problem was? You talked to them about it, you tried to correct it, they didn't correct it, and now you're going to fire them. So there is a little bit of a process that you should go through before terminating an employee or taking some kind of adverse employment action, even though we're an at-will employment state. So this is just kind of a risk mitigation strategy. Not to say that you cannot terminate somebody. You always can terminate somebody. It's just a question of whether that termination brings upon a big risk for the district. So that is my spiel about documentation. I always recommend that if you have job performance issues, to address them as they come up. Don't wait until you're completely fed up with the person to do something about it. The more documentation that you have of the issues, of your attempt to correct the issues, the better you'll be able to defend the district against a discrimination claim. All right, so on your screen, you see the Colorado Anti-Discrimination Act talks about some of these protected classes that I mentioned. This does apply to all employers, so even very small employers. Now, in contrast, a lot of our federal anti-discrimination statutes only apply to larger employers. So the ADA applies to employers with 15 or more employees. The Age Discrimination and Employment Act, this protects employees over the age of 40 from age discrimination. This one, you need to have 20 or more employees. So for you, some of these are less likely to come into play, but you have the same requirements under Colorado law. So, but I just want you to be aware these laws are out there here. Federal Civil Rights Act applies to all employers, regardless of the number of employees. So, you know, all these discrimination laws, I hope by this point, they're pretty, you know, much common sense, but they're a huge source of potential liability. All right, so that wraps up my bit on at-will employment and the anti-discrimination exception that we have to that doctrine. And I will talk now about wage and hour, and then move on to the Colorado's paid sick leave law. So the big wage and hour statute that applies to you is the Fair Labor Standards Act, the FLSA. And this establishes a federal minimum wage and also the overtime requirement for non-exempt employees. And that entitles them to 1.5 times pay for hours worked over 40 in a work week or over 12 in a work day. And this law came out of the Great Depression as an effort to create more jobs. The thinking was, instead of having one person work 80-hour work weeks, we could have 2 people work a 40-hour work week and double the number of jobs that are available. So that's the public policy that's underlying it. Now, in Colorado also has a wage and hour statute called the Colorado Wage Act. This does not apply to public entities. So if you happen to be doing some legal research on Google, which I don't recommend, but I know people do it. So if you come across a comps order that's published by the Colorado Department of Labor and Employment, just know that those don't apply to you. That can trip people up when you're looking online for information. Okay, so now I'm going to do a deeper dive into the Colorado Healthy Families and Workplaces Act. This is a really significant new law for all employers in Colorado, and went into effect initially in July of 2020, although it's been phased in since then, but it is now fully in effect and applies to you. All you need is one employee for this to apply. So it requires that every Colorado employer provide paid sick leave to all employees, full-time, part-time, seasonal, temporary, at the rate of 1 hour per 30 hours worked, up to 48 hours in a year. And this was a revolutionary requirement, because prior to COVID, there's no paid sick leave requirement in Colorado. And it's been kind of remarkable to see the shift in public policy happen in less than a year. I mean, maybe even 6 months. We went from, pre-COVID in January of 2020 to having no paid sick leave requirement. And the following July, we have this. So huge change for employers. And this is a permanent law. This does not expire when COVID goes away or anything like that. This is here to stay unless the legislature amends it. So this paid sick leave begins to accrue on an employee's date of hire, and employees can use the sick leave as they accrue it. So you can't have a vesting period or any kind of probationary period with this sick leave. Now, of course, these are the minimums. You can provide more paid sick leave than this, and many employers do, and that's absolutely fine. You can also front load this sick leave. So you could provide 40 hours on January 1st for the entire year, as opposed to having it accrue as the employee works. Unlike vacation leave, you do not need to pay this out upon termination of employment. And some good news here, you can apply an existing paid leave policy, for example, vacation leave or PTO, to satisfy the requirements of healthy families. So as long as you allow your employees to use paid vacation leave or PTO for the reasons that are provided under healthy families, then it's fine to just allow them to apply that bank to the sick leave requirement. So let's talk for a minute about why or when employees can use this paid sick leave. It can be used for a number of reasons, some of which might surprise you because they kind of go beyond what you might think of as sick leave. So they can be used for the employee's personal use, for a physical or a mental illness, for going to the doctor, getting preventative care. And I think that's what we would typically think of as a reason for using sick leave, just to care for yourself. You can also use it to care for a family member. And family member is broadly defined in the statute. So I wouldn't get into arguments with employees about whether their person that they need to care for is really a family member. It's a broad definition. Now, somewhat surprisingly, it can also be used if the employee is a victim of domestic violence, harassment, or sexual assault, and they need to seek legal services, or they have a court date, or they need to get medical care or mental health care that's associated with that. And then finally, sick leave can be used during public health emergencies to cover situations such as the employee's child's school is closed due to a positive COVID case, or the child has to quarantine, or the employee needs to quarantine. So that's another broad category that healthy families will allow the use of sick leave for. So another area that healthy families has kind of turned things upside down is in the has to do with how sick leave gets requested and then the documentation that's needed to support the need for sick leave. So it's very common for employers to have policies and procedures that explain how employees need to request sick leave and the documentation that they need. Well, Healthy Families has come in and changed some of that by saying it's fine to have policies, but you can't deny an employee the right to use sick leave just because they don't follow your policies. So your policies in effect become kind of a best practice type of thing, not an absolute requirement that employees have to follow. So under Healthy Families, employees may request sick leave verbally, in writing, or electronically. So you cannot require them to call the supervisor. That's a typical requirement. You can't do that anymore. You need to make it as easy as possible for them to request sick leave. When the need for sick leave is foreseeable, you can require them to use their best efforts to give advance notice. But again, this is not a hard and fast requirement. You can't deny them the right to use sick leave just because they don't give you notice. Now, the biggest change, I think, for most employers comes to documentation. So you cannot require documentation to support the need for sick leave unless the employee has missed 4 or more consecutive work days. That's a huge change, because being gone 4 consecutive work days, that's a long time. I mean, most people call out sick for a day, not 4 consecutive days. So if you have somebody call out sick for 1 day, you cannot require documentation. It's on the honor system. Now, if they are out for 4 or more consecutive days, you can require reasonable documentation. So what does that mean? Well, like all things that need to be reasonable, it depends on the circumstances. So it could be a doctor's note. If the employee went to a doctor, then they can provide a doctor's note. But if they didn't go to a doctor, or if it would cost additional money for them to get the doctor's note, then you can't require that. So in that circumstance, an employee can just provide their own note that says, "Dear boss, I was qualified to take sick leave on these days." So that's a big change. So Healthy Families creates two types of paid sick leave entitlements, the paid sick leave that I just talked about. And then the second type is called public health emergency leave. And this was in direct response to COVID. And this applies to all employers, regardless of size. And it states that when a public health emergency is declared, all employees are entitled to 2 weeks of paid leave. And full-time employees, this would be 80 hours paid sick leave. For part-time employees, it's just 2 weeks of whatever their regular schedule is. So all of your employees are entitled to this. Now, if they have accrued paid sick leave, or if they have accrued vacation leave or PTO, you can apply that towards this requirement. So the idea here is when a public health emergency is declared, the state wants to make sure that every employee has at least 2 weeks of paid leave available to them should they need it for reasons that are related to the public health emergency. So I'll give you an example. If you had a full-time employee with 40 hours of accrued leave, we'll just say it was vacation leave, in their bank when a public health emergency is declared, they would need an additional 40 hours of public health emergency leave to be added to their bank to be used for specific reasons that I'll talk about in a minute. If you have say you hire an employee during a public health emergency, you need to give that employee 2 weeks paid leave in their bank right off the bat. And this can be a little counterintuitive for employers because basically the less accrued leave somebody has, the more they get under this as a supplemental leave. But this leave cannot be used for a vacation. There are restrictions on how you can use this. So, and I'll talk about that in a minute. So use of public health emergency leave can be used for a wide variety of reasons related to whatever the public health emergency is. Now, in this case, I'm going to refer to COVID just to make it easier to understand. And that's what we've been living for the last 2 years. But this law is written in a way that it could be a different public health emergency. It's very general, but if you have one declared, and yes, we are still in a public health emergency for COVID. But once you have that emergency declaration, that's when this kicks in. So I'll refer to COVID just for shorthand, but do know that it can apply in other situations as well.
Can I ask a question real quick?
Oh, sure.
So you said they were still in a public health emergency. The governor, I believe, took away the emergency order. So does that change anything? Like, does it have to be a declared public health emergency by the state?
So the current order expires, I believe, April 6th. But I know there's been a lot of confusion about this because there are different orders. But for purposes of Healthy Families, we are still in a public health emergency.
Okay, thanks.
So, sure thing. So this leave can be used for the employee if they need to self-isolate or quarantine, or they have COVID for themselves. Also for a family member, if they have a child who has to quarantine, then they can stay home and take care of the child. If the employee's presence on the job would jeopardize the health of others because they have COVID symptoms, they can take this leave. If the child's school is closed for COVID, they can take this leave. Or if the employee has a health condition that makes them more susceptible to COVID, they can take this leave. So as you can see, it's pretty much anything that has to do with COVID, you're probably going to be able to take this leave. This leave can be used until 4 weeks after the end of the public health emergency. And, fingers crossed, hopefully we are nearing the end of this. But do know that when the emergency declaration when it expires, then you have 4 additional weeks to use this leave. This leave does not get paid out upon separation of employment. This really, the public policy here, I think, is really clear that the state wants to make sure that people who have been exposed to COVID or have COVID or their lives have been disrupted because of COVID for whatever reason, have the ability to stay home and continue to get paid. They don't want people having to choose between a paycheck and their health. So documentation, very important here. Employers cannot require documentation of the need to take public health emergency leave. This is 100% honor system. With paid sick leave, you can require reasonable documentation if the employee misses 4 consecutive workdays. But here, no documentation. And I recommend you don't even ask for it. It could set you up for a retaliation claim. Just if an employee says they need to take leave for one of these reasons, they get to take leave. So you can use your existing paid leave banks to meet these requirements. As I mentioned, I want to make sure you know that you don't have to automatically give everybody 2 paid weeks of leave. You just need to make sure everybody has that available to them. And also, employees can only use this leave 1 time per public health emergency. One little nuance here. This portion of the law went into effect on January 1st of 2021. And so that would be your beginning point for determining whether or not somebody has already used this leave. If they used a paid COVID leave benefit in 2020, that didn't count. That was under a federal law that's expired. So that January 1st, 2021, that's your starting point. Right, that wraps up public health emergency leave.
So Nikki has a question in the chat.
Oh, sure, let me take a look. Okay, is the public health emergency leave determined only by statewide public health emergency designation? What about local public health departments? For purposes of healthy families, the public health emergency leave is the statewide designation. And I should have mentioned earlier, if anyone, as you have questions, please feel free to put them in the chat and I will take a look at those. Okay. Moving on now. That my PowerPoint's frozen. There we go. Oh, one more. This isn't healthy families, but it's related to public health emergency while we're on the subject. If an employee raises a concern about your safety practices related to a public health emergency, let's think about masks. I think that's the most kind of obvious example here. Say that there's an indoor mask mandate and the place of employment is not enforcing that, or they're not following it. An employee says, I'm concerned that we're not masking indoors in accordance with the mask mandate. You cannot punish that employee for raising that concern or expressing that concern. So this is a whistleblower protection law that is new and was adopted, I imagine, with mask mandates in mind. So this applies to all employers. So be sure you don't penalize anybody for expressing their concern about that stuff. All right, now that wraps up the public health emergency and sick leave. component. Now I'm going to talk for a bit about family and medical leave. So the big federal statute in this area is the FMLA, the Family and Medical Leave Act. And this applies to employers with 50 or more employees. So this is not one you need to worry about. It entitles employees to 12 weeks of job protected leave, unpaid, but this is really only for larger employers. Colorado also has what is called Colorado FMLA. And this one, again, you don't need to worry about it because you're not subject to FMLA, but it provides kind of a broader definition of family relationships. Okay, now here's one to focus on. This is, oops, what happened to it? Oh no, I'm sorry. I've got something wrong with my animation here. Well, oh, there we go. Okay. Family. This was adopted by voters statewide, Proposition 118, I believe, in 2020. And this is going to set up a state-run family and medical leave insurance benefits program. And it will go into effect in 2024. Starting in 2023, employers and employees will start paying premiums into this program. And this is going to establish a paid family and medical leave program in Colorado. The local governments can opt out of this with a vote of your board. And you do need to provide notice to employees and give them an opportunity to provide comment to the opt-out. If you do opt out, your employees can still opt in. And then you would deduct their premiums into this insurance program and send them on to the state. The opt-outs by local government will be effective for 8 years, and then you can renew it. These rules are just starting to come out, and more rules are coming. We're going to get more information on premiums and how that's going to work in the coming months. So I would watch this one. We don't have the full picture on how this program is going to work, but this is going to be a big change. Okay, so next topic is the Colorado Equal Pay for Equal Work Act. This is another big one, similar to Healthy Families and Healthy Workplaces Act. It was came into effect around the same time, and it has put a lot of restrictions on the way that salary information is used in the hiring process and the way that job positions get noticed to employees. And the problem that this statute's trying to address is this widespread, persistent issue of pay disparities between men and women in Colorado. And there's a federal equal pay statute. I mean, it's not new in terms of a requirement that you cannot discriminate between men and women or on any other basis and pay. I mean, that's not a novel requirement. But what this statute, what is novel is the way in which the Equal Pay for Equal Work Act goes after this issue to try to really fix it. So the first requirement is you can no longer ask job applicants for their wage history. And this is a really common job interview question. What are your salary expectations? What do you currently make? You can't do that anymore. So next time you're hiring for a position, make sure that question is stricken off your list. And you'll see in a minute, I'm going to talk about why it's really a moot question now too, because you have to advertise the salary range for the position in your job posting. So a particular job applicant's salary history or salary expectation is not very relevant. So another requirement of this law is that if you have a position that's open and you're trying to fill it, and that position could be considered a promotional opportunity for any employee, even if they're not qualified for it, you still need to post that position on the same day to all employees. And I think what this is trying to get at is it's trying to kind of address, like, backroom deals and where you've got a supervisor who just really likes one person, and so they move them up to that spot without giving everybody the opportunity to apply for that position. So it's just trying to create more transparency in the hiring and the promotion process. So, but again, this is another big new requirement. Most employers don't do this. So this is something you've got to kind of get into the forefront of your mind whenever you're hiring for a new position. Now, you do not have to post a job opening externally, but if you do, you also need to provide this internal notice so that your current employees have the opportunity to apply for it. Now, the notice must contain the compensation range for the position, a general description of benefits, and the job title and description, and then how to apply. So I mentioned before why, it's kind of moot to ask a job applicant for their wage history. And that's because in the notice for the job, you have to say what the compensation range is, and it needs to be a good faith guess. I mean, you can't put, the range is between $25,000 and $200,000 per year. I mean, that's not going to fly. It needs to be, the real range that you are willing to pay for the position. And if you look on, job posting sites like Indeed or ZipRecruiter, you'll see this now, where all these job postings include the compensation range. So it's kind of interesting. It's a big change in the way that hiring works. This law also has some record keeping requirements. You need to keep employee records and for the length of the employment plus 2 years. And this law applies to everybody with at least one employee in Colorado. All right, so that is the Equal Pay for Equal Work Act. As I mentioned, there's also a federal Equal Pay Act. This one applies to employers with 20 or more employees. It's probably not going to apply to any of you. And really the Colorado statute is so much more restrictive and specific on what's required that you don't need to worry about this.
Okay, so I was typing, but I'm too slow of a typer. So my question is, so if you're not allowed to ask any questions related to their past pay, then once you've determined that you're going to hire someone, how do you determine within the range that you've specified what their wage will be?
So as long as you're within that posted range, you have discretion. So based on their experience or their qualifications, you would just make the determination, and then there's a negotiation with the applicant.
So could the negotiations include discussion on what their current wage is, or are you still not allowed to know what their current wage or their wage history is at all, period?
Yeah, you're not allowed to ask for it. If the applicant just tells you,
okay,
then there's nothing you can do about that, but you can't ask for it. So if the range is $40,000 to $55,000, you're free to negotiate within that range.
Okay.
All righty. So next up, I have just a list of statutes that I will briefly mention. Just want you to be aware of them. Some of these will apply to you, some of them won't. But my hope here is that if you ever run across one of these issues, it might trigger a memory for you of like, oh yeah, there's a law about that, or that one doesn't apply to us. So just going to do a broad overview here. So USERRA, Uniform Services Employment and Reemployment Rights Act. This provides some special employee leave benefits for active military service members. And this applies to all employers. And the thing to remember here, if you have somebody who is enlisted, an employee who's enlisted, and they get called up to active duty, don't fire them. They have the right to leave. Colorado Employment Opportunity Act. This limits the use of credit information in the hiring process and also employment. So you cannot just run credit checks on your employees or on job applicants unless it's related to one of their job duties. So if you have an employee who's handling district funds, this might be appropriate, but you can't just do this with everybody. Similarly, criminal background checks. There are limitations on the way that you can use that information in employment. There's a very strong public policy in Colorado in support of integrating people with criminal backgrounds into society and giving them the chance to have gainful employment. And so if you find out an employee of yours, has something in their past, unless it is somehow related to their job duties, just let it go. I had a situation come up recently where one employee came to the district manager and said, did you know so-and-so is a registered sex offender? And this was shocking to everybody. But it's okay. There's nothing, as an employer, you can't do anything about that. There are no job performance issues with this employee. This employee did not have any access to vulnerable populations as part of his job. So, I tried to calm everybody down. It's okay. So you got to be really careful about the way that you respond to that type of information. Workers' Compensation Act. This is pretty straightforward. I think everybody knows about this one. Just provides medical benefits and disability for injured workers. This applies to everybody. There are some time restrictions on when these injuries need to get reported, and a lot of statutory requirements here. OSHA does not apply to public employers in Colorado. So this is one that you can just cross off your list of things to worry about. Unemployment benefits, I think we're all pretty familiar with these as well. This applies to all employers. And finally, I don't know how often this would come up for any of you, but just so you know, if you are going to hire a minor employee, maybe for a summer job, there are restrictions on how many hours they can work and the type of duties that they can do. So that would be something to check into before you finalize that. And that is everything I have today. I would love to answer any questions you have. Like I said, there's no bad questions. So please feel free to put them in the chat or chime in however you feel comfortable.
Yes, I have a question.
Sure thing.
If a employee is not coming to work, hit and miss, not calling in, not giving it any excuse, do we just dock their wages, or do they have to get sick leave or vacation leave?
Well, is there any explanation that the employee is giving?
Well, the first time it happened, she said sometimes she has anxiety attacks and just can't come to work. And I said, I understand that. Just text me or have your husband call or let me know somehow what's going on. But it got so, I mean, she just came when she wanted to. She's now resigned, so the problem's over with, but I'm still curious.
Right. Yeah, no, that's kind of a thorny situation because she would qualify for the paid sick leave if she has it. You know, if she hasn't, if she is out of paid sick leave or hasn't accrued enough to cover a full day, then you know, she's an hourly employee. You don't need to pay her for hours that are not worked. But you know, with the notification requirements under the Healthy Families Paid Sick Leave law being so accommodating of employees, it's you know, it puts employers in a difficult situation. But if she has run out of her accrual, her paid sick leave accrual, then you have some more flexibility. But in that case, I would just encourage you to communicate as much as possible with the employee and tell her, I mean, like you said, like you gave her multiple avenues for calling in sick. You said her husband could call for her. I would just make it as easy as possible for them to communicate with you.
And so I take it that doesn't have to move into vacation at all. These are sick days, so.
If your vacation policy, I mean, most likely your vacation policy would allow that time to be used for that reason. I mean, usually they're really broad, but I mean, as long as there's nothing in your policy that would prevent her from using it in that situation, then yes, she could also use that.
All right.
Once the employee is out of paid accruals, it changes the analysis a lot. I mean, then they're just not getting paid.
Right.
So
we got to that point at one stage. And she accrued a few more. So, okay. And a different question. When a person leaves work, we do not have to pay accrued sick leave.
Correct.
Vacation leave.
Yes.
Yes. What?
You have to pay it.
Okay.
Vacation and PTO, paid time off, get paid out at termination of employment. And paid time off, that is an alternative to doing the vacation and sick. So some employers will have a vacation bank and a sick bank. And an alternative to that is just to lump it all together and call it paid time off and say, you can use this for whatever. If you're not at work for whatever reason, I don't care if you're on vacation or you're sick, you can have the paid time off. So vacation leave gets paid at termination and PTO gets paid at termination. Right. Sick leave does not.
Thank you.
Sure thing. Let me check the chat here. All right. What are the regulations of compensatory time? Is this allowable for public employers? Yeah, you need to have a policy about using compensatory time. That is not something I'm seeing a lot of these days. Yeah, I haven't seen, I'm sorry, I'm just thinking through how that would work with healthy families. With the paid sick leave and the public health emergency leave requirements. You need to have a policy, a written policy about it. Right, any other questions?
This is Callie. I do have a quick question. I was under the impression that the difference between hourly and salaried And so is it 45,000 is what they have to be making if they're full-time in order to be salaried? And I'm trying to think, I lost the term between exempt or non-exempt
Exempt or
employees. Is that accurate? And then you have to do you do have to do comp time if they work over 40 hours, if they are hourly. That's been the direction I've been given.
Right. I think I haven't looked at that threshold in a long time. So, you know, I
Okay.
would want to confirm it. I think the threshold's $40,000. But the exempt and non-exempt categories of employees, that comes from the Fair Labor Standards Act. And that analysis that you go through depends on the job duties and how much they're supervised and how much autonomy the employee has. And there's a whole list of factors. And then there's also the salary basis test that you're referring to.
Mhm.
So in categorizing employees as exempt or non-exempt is it's important to do that carefully, because exempt employees are not entitled to overtime, and non-exempt employees are entitled to overtime. So if you mess up that classification, it can, you know, there can be some severe penalties for that, because you could put yourself in a situation where you're not paying overtime to somebody who's entitled to it. So, but there's a lot of nuance to all that. It depends a lot on the particular job duties and the industry and all that. So, does that help?
Well, so just my understand, because we had determined our district manager to be an exempt position. But as of the first of the year, our accountant let us know that if that person was not making 45,000, they could no longer be exempt.
Okay.
So then that really changed how we have to manage things.
Right.
And it's become it's just a headache for everybody. And we can't, you know, because what we were doing is still didn't really make anybody work over the 40 hours. But if you worked 45 hours this week, you could use that later if that worked out better for you.
Right.
And now my understanding is we cannot do that. And that's just a real challenge for everyone.
Because he's non-exempt.
Right.
Because he doesn't meet the salary
Correct.
threshold. Okay. Sounds like that salary threshold has gone up, which.
Yeah, as of the first of the year, my understanding is that.
Okay. Okay. That makes sense and not surprising.
Yeah.
But yeah, you do need to meet that salary requirement to go into the exempt category.
Okay.
And that's not the only requirement, but
right.
It's one of them. Yep. Let's see. Let me check the chat here. Do the new sick leave rules apply to full-time and part-time employees? Yes, they do. So the accrual rate of 1 hour per 30 hours worked, that applies to everybody. And even your temporary employees, seasonal employees, everybody. And same for public health emergency leave. Are there any more questions? Good. Thank you, everybody, for joining me this morning and for your time. If you think of anything else, my email and my phone number are on the screen. So please don't hesitate to reach out. I'd love to hear from you. And I hope this was helpful for you.
Yeah, thanks, Allison. We really appreciate it.
Thanks for having me, Nikki.
Yeah. All right, everyone. We'll have a good rest of your day and we'll be in touch soon. Take care.
Bye-bye.